Hey, good morning, folks. I'm attorney Roger P. Foley, and I'm driving to the courthouse this morning. And yesterday I was reading about the case, a Florida Supreme Court case, leaving the scene of an accident with death. Now, I can't tell you how many cases I've had of leaving the scene of an accident with or without injuries. And the pinnacle of that is if someone is seriously injured, serious bodily injury or death. If it's with death, it's a first-degree felony. So you're facing up to 30 years, and there's a 4-year minimum mandatory sentence in Florida. Now, the thing that gets me is most of these cases, the person panicked. And you always have to explore what the reason is. Why did they panic? Did they have a suspended driver's license? Had their insurance lapsed? Were they drinking while impaired by drugs or alcohol? Really, that's the issue. Or were they just scared? Well, here's the reality, folks. It doesn't matter. So in this Florida Supreme Court case, and I can't remember the name of it, maybe I'll add it in the description. A child or a young lady is riding her bicycle and goes to the crosswalk, but I guess doesn't hit the button, which would illuminate it to let people know that there's a walker, a pedestrian, a bicycle going past. And ultimately, the defense was filing a motion for downward departure, saying that probation is sufficient, he's remorseful, it's an isolated incident, all the reasons that you do a downward departure. Now, a little weird because my understanding is on a minimum mandatory, you can't do a downward departure. But I don't know, regardless, and I have to research that, but that's my understanding, that if it's a minimum mandatory, if you have a minimum mandatory 3 years, 5, 7 years, whatever, 14 years, 15 years, you can't do a downward departure because the judge doesn't have the discretion. But let's put that aside for a second. Maybe I read something or I was reading it too quickly. What happens is the state says, hey, we have this charge, and I guess the charge on the Florida Punishment Code scores, I think it's a minimum of 4 years, something like that, and the defense is saying, hey, we don't think it deserves 4 years. Sure, it's a loss of life, but it was truly an accident. And the state said, you know what, we think that the injury points, severe injury points, should be applied, because the Florida Punishment Code has something for the level of injury. Is it minor injury? Is it a major injury? Medium injury? Death? That kind of thing. Well, the points that are assigned in the Florida Punishment Code added like another 10 years to the bottom, meaning there's a range, right? So if it's from 4 years to 30 years. And ultimately, there was a hearing on it, and the defense said, well, you can't prove that it was our fault, and the defendant isn't being charged with vehicular homicide. That's what happens in a vehicular homicide, and he's not charged with that. He's charged with leaving the scene of an injury that resulted in death. It's a sad story because, while you think about the legal part of it, think about the emotional part of it. Think about the family member, the family, right? That lost a loved one, a child, or maybe a teenager. That you got to think about that, right? I mean, as a defense attorney, you're sitting there and you're trying to argue points, and right, the victim's family is showing up for hearings. So when you say it's a delicate matter, you always hear people, well, I got this victory, I got that victory, but at whose expense? And that's part of it, As a defense attorney, our job is to help the defendant. The state's job is to represent the victim and the victim's family. So you can imagine everyone thinks that they have an argument, but there's a loss of life. So I think that's, first of all, you need to recognize that. But ultimately, the court said, no, we're going to add the points, and the Florida Supreme Court said yes, and the defendant was sentenced to 15 years Florida State prison. Now, I don't know if he gets early time off and only has to do 85%. That's a possibility. Honestly, I was reading it, but I got interrupted. It was a really long opinion. So the reason I bring it up is, I don't know, I've had dozens of these types of cases where there's leaving the scene of an accident. And folks, if your driver's license is suspended, okay, it's an extra charge. If you're impaired, okay, right, and someone dies, you're going to have a manslaughter case. But where is the empathy? Where is the love? Where is the caring of your fellow human being? You hit somebody, whether it's your fault, whether you caused the accident or not, or someone ran out into the street. It's crazy because I can't imagine. I get it. People get scared. Oh my goodness, they stop the car, they look, and they see someone tumbled on the side of the road and they're not moving. I can only imagine that fear, that pain, that anxiety that's going to come up. But the first thing you got to be doing is dialing 911. Here's the reality. When you call 911 and help your fellow human being, regardless of the result, whether it's you could just hit a parked car, right? You don't know who's in the car. There could be a child sitting in the car, right? You don't know. It shows that you have a level of humanity, that you care about others, that you're not a me person. And that goes a far way if a charge is brought. Sure, you could get away, but you know what happened in this case? The gentleman says that he stopped, but he saw that police and EMS were on the scene helping the girl, and he said, hey, they got it, and he left. That got him a 15-year prison sentence. You can say you stopped, but you need to identify yourself. And here's the reality: if it was truly an accident, never would have went to jail. On a death or a serious bodily injury, the Florida statutes allow law enforcement to take a blood sample. Right? They take a blood sample, and you're not arrested on scene unless you're showing serious signs of impairment. 98% of the time they're going to take a blood sample. Well, anytime there's a serious bodily injury or death, they're going to take a blood sample. So it's 100% of the time. And then those results are going to come back somewhere between 6 and 10 weeks, maybe 3 months, 12 weeks. And if you're not impaired, if you don't have a substance in your system, you're not charged because it was an accident. And you acted like a normal human being. You stopped, you rendered aid, you called law enforcement, you dialed 911, you said get him an EMT here as quickly as possible, and you did whatever you could to assist the injured party. When you don't do that, in the hopes that you're going to get away, you don't get away. So this person, what did they do? They left the scene, and they took their car to a body shop and said that a tree fell on it. Well, it's very rare that you don't get caught. I'm not saying, here's the reality. I'm just going to put it this way, and I know those that love law enforcement, you're going to have a different perspective. Facing law enforcement versus facing your deceit, you have a much higher likelihood of victory facing law enforcement. Facing the person that does the accident reconstruction, the officers, the chain of evidence with your blood, the lab for attacking the results of the blood test. way higher chances. That's the reality. Way higher chances than you left the scene. What else has to be said? Officer, when you got to the scene, was there anybody there? No. At some point later, did you come to? Yes, I did an investigation. Someone got a tag. We pulled the traffic lights, the traffic cameras. We got an anonymous tip. Right. Now you're deceitful. Now nothing that you say or do can be believed. And where's the empathy? Where is the? You can't. Your defense attorney is like, the hands are tied. So if you hit a parked car, you stop. If you, and just know this too, the accident report privilege, right, in Florida, means that if you're in an accident and you're asked questions in regards to were you driving, you have to answer it. But that information cannot be used in a criminal case. So what normally happens is an officer shows up on scene, goes, what happened? Oh my goodness, I ran the light, I hit the person, I was distracted, whatever. They can't use that against you in a criminal case. So now what they do is, it sounds weird, but this is what they do. They then read you Miranda. Once you hear Miranda, folks, right, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to counsel. As soon as you hear that, I don't wish to speak until I have an attorney. That's it. And guess what? Whatever they learned during the crash, right, during the crash investigation from your mouth, it can't be used against you. So I'm not trying to teach anyone how to, I'm asking people to be responsible and caring, and know that if you are charged with a crime, that your likelihood of success by doing things the right way, keeping your mouth shut when it's appropriate, right, and facing law enforcement, you have a much higher percentage shot of staying out of a prison cell. I'm attorney Roger P. Foley. Please listen to my words. See ya.